A very, very good evening to all of you, friends. A very, very good evening to all of you. Welcome to BYJU'S Exam Prep, the most comprehensive preparation app for all exams. So, friends, today we are with the weekly legal current affairs for the month of February. So, what were those important news insofar as the legal development of this country is concerned? That is all that we are going to study in this particular session. So many legal development did take place in the last week. Of course, it was a holy week. Most of the courts were closed, but yes, of course, some of the major legal developments that has taken place in the previous week, that is all that we are going to talk about in this session. And why is this session so important? This session is important owing to the fact that insofar as your CLAT examination is concerned, the kind of questions that you get are all passage-based questions. These passages are based on legal current affairs, legal development that are taking place or that has taken place. So in view of that, let's begin with this session on weekly legal affairs. So guys, let's begin. But before we begin, BYJU'S Exam Prep brings to you a free workshop on what to study and what to skip for CLAT 2024. This particular workshop is scheduled on 12th of March at 6 p.m. This particular workshop will be very, very important for each and every one of you preparing for CLAT 2024. This workshop on what to study and what to skip for CLAT 2024 will be taken by BYJU'S Sir. So hurry up and register now for this workshop. Moving on, let's begin. A very important order coming from the Kerala High Court. Registration of a subsequent FIR does not mean that a person, now suppose a person, an FIR is filed against Mr. A. So against Mr. A, FIR 1 is filed. And on this particular FIR, he has got bail. And thereafter, another subsequent FIR is filed, FIR number 2. The subsequent filing of an FIR does not mean that the bail that was granted should be cancelled. The question is, should the bail granted in one crime be cancelled merely because the accused had an alleged violation of the condition of bail, got himself entangled in a subsequent crime? So the Kerala High Court says that registration of a subsequent case cannot result in an automatic cancellation of a bail in an earlier case. So what did the court say? The court said that bail once granted ought not to be cancelled, should not be cancelled for the mere asking. Just because the state is saying that the bail is cancelled, it should not be cancelled. There must be cogent and overwhelming circumstances existing to cancel the bail, which should not be restored to a mechanical manner also. So just because the government or the state is asking that a bail that is granted to an individual should be cancelled, the court should not cancel it. The court must get into the reason. What is that cogent or that overwhelming circumstances that exist for the cancellation of bail? It should not be done in a mechanical manner. The court said that mere registration of a subsequent crime against an accused by itself cannot result in automatic cancellation of bail. Registration of a subsequent crime is only an indication of an alleged or a complaint that the accused having been involved in a subsequent crime. Presumption of innocence available to the accused in the second crime, the right to liberty as a fundamental right under Article 21. See, just because a subsequent FIR, a subsequent case has been, a crime has been lodged against a particular individual, does it mean that he loses his fundamental right to life under Article 21 of the Constitution? No. Now, what does the court say? The fundamental right under Article 21 of the Constitution, which envelopes every provision of the Code of Criminal Procedure as factors which cannot be forgotten by the court when called upon to cancel the bail. The possibility of false accusation being alleged with oblique motives cannot be ignored also. It's very, very important. The possibility of false accusation alleged for ulterior motives or oblique motives should not be ignored by that court also. Did you understand? So just because a second FIR is filed against an individual who has got bail in the first FIR does not mean that the court is going to just mechanically cancel the first bail that he has got. He has all rights under the Constitution, Article 21 rights, right to liberty, as well as rights that are provided under the Code of Criminal Procedure. The court also went on to say that the nature of subsequent offense and the person against whom the offense is alleged have been committed, the stage of the crime or the case wherein cancellation is sought are also factors that require appreciation apart from the above. While arriving at the conclusion to cancel the bail, court must also consider whether the accused has misused the liberty granted in such a manner that it has a tendency to interfere with the due course of administration of justice. Thus, every case presents a unique situation, and close scrutiny ought to be indulged into identify whether overwhelming circumstances are indeed present in the subsequent crime which necessitates the cancellation of bail earlier granted. So all that I am trying to say, the High Court of Kerala in a particular situation held, in this particular case, held that just because a subsequent FIR or an allegation or an accusation of a crime against an individual has been done, doesn't mean that the bail that he has been granted by the court in the earlier FIR should be cancelled. The court said that very cogent and overwhelming circumstances are necessary to cancel the bail already granted, and that bail once granted should not be cancelled in a mechanical manner without considering whether the supervening circumstances have rendered it no longer conducive to a fair trial to allow the accused to retain his freedom by enjoying the concession of bail during the trial. So generally, bail should be given. Jail is an exception to the rule. Bail is the rule, jail is the exception to the rule. Am I clear to each and every one of you? Okay, am I clear to each and every one of you watching me live, guys? Okay, fantastic. Okay, any doubts, you are most welcome to ask me your doubts. Moving on. Before we move ahead, BYJU'S Exam Prep brings to you a comprehensive course for CLAT 2024. In this particular course, we shall give you 300 plus recorded videos across 5 sections, 300 plus hours of live classes, 35 mock tests for CLAT and other law exam with video solution, monthly e-magazine for current affairs, and the entire content is curated based on an extensive analysis of the last 5 years of CLAT question paper. Moving on. Next, the question before the Madras High Court was, can a single judge overrule a division bench order. There is an hierarchy of courts. There is the rule of law. Now, a single judge of a Madras High Court was trying to overrule an order that was passed by the division bench. Is it possible? The answer is no. The court said that we have to necessarily hold that the finding and the direction issued by the learned single judge, contrary to the discussion, observation, direction issued by the division bench, must be held to be non-est in the eyes of law, as if it does not exist in the eyes of law. Now, please try to understand that there happens to be a hierarchy of courts. Now, you go initially to the district court. You are not happy with the district court's order. You go to the high court. In the high court, you file a case before the single judge. If you are not satisfied with the single judge's order, you go before the division bench. You might not be satisfied with the division bench order. You come to the Supreme Court. Now, the question is, a judge, single judge, who is sitting in singly, is in the hierarchy is lesser than the division bench, right? So how can a single judge issue orders or direction contrary to the directions or orders issued by the division bench? It cannot happen. The court said the learned single judge should have exercised restraint, caution, ought not to have sat on the considered judgment passed by a division bench, and any orders passed by this honorable judge must be taken to be without jurisdiction, as it violates or vitiates the order that was passed by quorum non judice, because the quorum was not good. Now, a division bench's order can be overruled by a full bench, okay? 3 judges sitting together of the High Court. Now, can a judge of the High Court, can a division bench of the High Court overrule an order passed by the Supreme Court? No. If such things happen, then there will be a mockery of the judiciary. So, a single judge's order, a single judge cannot overrule the findings or direction given by a division bench. Moving on, the Supreme Court has summarized the rules relating to compassionate appointment. The Supreme Court, what did it say? I'll just read it out. You will understand it very well. That a provision of compassionate appointment makes a departure from the general provision providing for appointment to a post following a particular procedure of recruitment. Now, why is compassionate appointment given? Now, let me just tell you. Now, suppose a person who is working with the government of India in a particular job. Now, suppose he dies and he is the sole bread earner of the family. Now, since he dies, the entire family will starve to death. So, compassionate appointment is a procedure wherein a member of the family of the deceased, the person who died, his family member will be given a particular job, his job, so that the entire family does not die out of hunger. So, that is called compassionate appointment. Now, it is given only so that for sudden financial crisis, so that the deceased family, the family does not go through some hard times, to prevent that. That a provision of compassionate appointment makes a departure from the general provision providing for appointment to a post by following particular procedure of recruitment. Since such a provision enables appointment being made without following the said procedure, it is in the nature of an exception. So, compassionate appointment is an exception to the rule of general appointment and must be restored to only in order to achieve the stated objective. That is, to enable a family of the deceased to get over the sudden financial crisis. So, the sole objective of compassionate appointment, The sole objective of compassionate appointment is to enable the deceased family to get over that financial crisis that has taken place owing to that person who died. Okay. Secondly, the Supreme Court said that appointments on compassionate grounds is not a source of recruitment. The reason for making such a benevolent scheme by the state or by the public sector undertaking is to see that the dependents of the deceased, very, very important, since the person who died is the sole breadwinner, the dependents are not deprived of the means of livelihood. It enables the family of the deceased, the dead, to get over the sudden financial crisis. Is that clear to each and every one of you? Are you guys all understanding? Okay, so this is a very, very important rules. The Supreme Court has just summarized the entire rules relating to compassionate appointments in India. Now, if you remember, just a year and a half back, 2 years back, there was a passage in your CLAT examination on compassionate appointment. So, legal developments will play a very important and a crucial role for your preparation for CLAT. The Supreme Court said that compassionate appointment is not a vested right which can be exercised at any time in future. Compassionate appointment cannot be claimed or offered after a lapse of time and after the crisis is over. Now, suppose a person who died is a very rich man. He did not had any financial crisis. Can his son or daughter after 10 years claim that job? No. It is only for getting over that financial crisis. Compassionate appointment should be provided immediately to redeem the family in distress. It is improper to keep such a case pending for years. Now, the Supreme Court is also suggesting that the government, when there is a compassionate appointment, should do it immediately, because if it is pending for years and years, it does not make any sense. That family recovers from that financial crisis. It is for that immediate time that the person goes through. Is that clear? Thereafter, the Supreme Court said that in determining as to whether the family is in financial crisis, all relevant aspects must be borne in mind, including the income of the family, liabilities, terminal benefits, if any, received by the family, age, dependency, marital status of the members, together with the income from any other sources. So, while determining whether a particular case should be given, whether a particular family should be given compassionate appointment, each and every aspect, income of the family, what are its income, what are its liability, has the family received some benefits after the death, what are the ages of the dependent. Now, suppose there is a kid who is just 2-year-old, a kid who is just 5-year-old, the schooling, the college, the fees matters, the marital status of the family, suppose there is a daughter. So everything must be kept in mind while determining whether a family is entitled to compassionate appointment or not. Moving on. Justice Ravinder Bhatt of the Supreme Court of India says that yes, there is a lot of fake news and hate speeches in India. The government, the parliament should make laws to address fake news and hate speeches. Justice Ravinder Bhatt, while addressing a conference, said that the absence of stringent regulation or framework of laws relating to control and ownership of media houses has unfortunately meant that private interests are having a chilling effect and being to dictate what is reported on the news in a newsroom. The ease of disseminating information and media has been double-edged sword. It has led to democratization of voice opinion by providing an accessible platform enabling cross-jurisdictional dissemination, debate and protest, and unprecedented access to knowledge. Now, media over the years media is the fourth pillar of the state. You have the executive, the legislature, the judiciary, and the free media. Now, right to freedom of speech is one of the very important aspect of our democracy. Now, unless and until we get proper information, how can we be informed? How can we have the knowledge of what is happening? Now, there is a lot of fake news going on. There's a lot of hate speeches being given. Now, I think it's time, that is what Justice Ravinder Bhatt says, that it is time that proper laws are required to be made to address freedom of the media from private ownership. Now, most of the TV channels are today bought by private entities. Now, if that happens, then a narrative goes, right? And it is not fair for a democracy, for a thriving democracy like India. That is what Justice Ravinder Bhatt laments in a conference while addressing a crowd. He also says, but it is also made the spread of fake news. Now, news channels over the years, what the kind of news channels we had seen earlier in our life, that a person, the news anchor, would come and make a particular news. He would tell about a particular news. Now, today there are debates and the news anchors are shouting, making false allegation against one party. And, news anchors should be like an umpire, should be like a judge, should be an anchor who is, asking questions to both the sides. Now, you have today news anchors leaning towards one side or the other, and these are not fair in a democracy. That is what Justice Ravinder Bhatt says. He says that, but it is also made the spread of fake news and false narrative and hate speeches that much more easier. It is imperative for us to protect and promote the former and direct concern of effort in the form of legislation, in its absence, judicial intervention to tackle the latter. That is, in the absence of a law made by the parliament to tackle hate speech or freedom of the media, the judiciary will be bound to intervene in such situation. So freedom of the press also is a very, very important part of freedom of speech and expression as enshrined under Article 19 of the Indian Constitution. We all as citizens have a right to be informed and to discuss. We have a right to you have a right to criticize judgments of the courts. You might say that this judgment is wrong. You don't agree with a particular judgment. Let's not accuse a judge. That will be contempt. But you have every right to criticize a government. You have every right to criticize a judgment of a court. You have every right to criticize a law made by the parliament. Very well, no problem. But how will you criticize if you do not have the knowledge about these things that are happening? But today we are in a situation where there are a lot of news which are not true, and it is a narrative that has been shown. That is what Justice Ravinder Bhatt was deliberating about. Okay. So guys, BYJU'S Exam Prep brings to you a free workshop on what to study and what to skip for CLAT 2024. It's just less than a year. We are in the month of March. The CLAT 2024 is scheduled in the month of December. So you have around 9 months for your CLAT examination. In the next 9 months, it will be very important for each and every one of you to know what to study and what not to, right? This free workshop is scheduled on 12th of March at 6 p.m. So hurry up and register now. This free workshop will be conducted by Abhimanyu Sir. So guys, do subscribe and like this video. Do share this video with your friends who all are preparing for CLAT 2024 and other law entrance examination. Do follow us on our Instagram, do like our Facebook page, do join our Telegram channel, and do not forget to download the BYJU'S Exam Prep app from the Google Play. With this, we come to the end of this session. Thank you very, very much. God bless you. Stay home, stay safe, stay healthy. Bye-bye. Take care. Have a great weekend ahead. Thank you. Good night. All the best, guys.